We have some major developments in a brand new ruling involving the NFA's restrictions on suppressors. A 3-judge panel ruling out of the 5th Circuit of Court of Appeals issued a massive ruling that completely shifted the legal landscape for suppressors and also the Second Amendment. In a case called U.S. versus Camo, the 5th Circuit officially ruled that firearm suppressors are in fact protected arms under the plain text of the Second Amendment. But there is a massive catch in that ruling. Even though the individual won the constitutional argument that suppressors are arms, he still lost the challenge because the panel was completely trapped by a terrible prior ruling that was already issued by the 5th Circuit. But here's the kicker in this case. 2 of the federal judges on that very panel also issued a strong concurrence calling for an emergency en banc review to completely overturn that prior precedent that they were bound by and they want it completely done away with. And now we have a major update in this case. A petition for en banc rehearing has now been filed, and the 5th Circuit has just moved with lightning speed to trap the DOJ to have to defend this law. So let's break down what just happened, how this ties directly back into the tragic case of Mr. Peterson and that precedent, and why the NFA may now officially be on thin ice. Now, before we jump into what is currently going on in this case challenging the NFA's restrictions on suppressors, if you like this type of video and you want to support the channel, make sure you like, comment, subscribe, and turn on all notifications to ensure you never miss these videos when I release them. Now, to understand how huge this new ruling is, we have to look back at the devastating precedent that was just issued and really trapped the defendant in this case. It all stems from the case U.S. versus Peterson, a major suppressor challenge that we have covered here on this channel. In that case, law enforcement officers raided Mr. Peterson's home-based FFL and found an unregistered suppressor, really a solvent trap, in his bedroom safe, and the DOJ hit him with a standalone NFA violation that carried 24 months of prison time, and so he was sentenced to prison time. Now, Mr. Peterson challenged the NFA under the Supreme Court's Bruin framework, so he brought a two-way challenge to those NFA restrictions, and in that case, the 5th Circuit did something incredibly dangerous. They claimed that the NFA is presumptively lawful because it operates like a shall-issue licensing system. Essentially, that panel's ruling established a decision and really precedent saying that as long as the government has an objective process to register and tax you, the restriction can in fact survive. Now, Mr. Peterson appealed up to the Supreme Court, but the Supreme Court refused to step in. And because of that inaction, Mr. Peterson's final request to modify his sentence for home detention and just house arrest, really, that was denied. And currently he had to report to federal prison where he's currently, serving that prison sentence that was issued against him. His case became a tragic real-world example of the state of this current law. The government could admit an item is in fact protected by the Second Amendment, but still lock you in a cage for failing to register it under the NFA. That brings us directly to this new decision in the U.S. versus Camo case. Now, in this case, Mr. Camo was prosecuted under the exact same federal statute for possessing an unregistered suppressor. He argued that the NFA violated his constitutional rights, but the district court flatly rejected that claim, essentially arguing themselves that silencers are dangerous and unusual weapons, not protected by the Second Amendment at all. After that lower court ruling, he then appealed up to the 5th Circuit. It went to a 3-judge panel, and this new panel just did something unprecedented. The court explicitly ruled that suppressors absolutely are protected arms under the Second Amendment. Writing for the court, Judge Jerry Smith dismantled the DOJ and government's arguments that, suppressors are not protected arms. The court recognized that suppressors reduce loudness, lower the risk of hearing loss, eliminate muzzle blasts, and also increase accuracy. The court ruled that these are critical functions that make a firearm safer and more effective for the core lawful purpose of self-defense. Under Bruin, an item does not have to be strictly necessary for a gun to actually function. Instead, it just has to facilitate armed self-defense. So this was a massive constitutional win. The 5th Circuit has officially cemented into law that suppressors are protected arms under the Second Amendment. This also creates a direct circuit split as well with other circuit courts like the 9th Circuit, where they recently ruled themselves that suppressors are not protected arms. Now, you may be thinking to yourself, well, if suppressors were found to be protected arms in this case, why was Mr. Comeau's conviction still affirmed by the 3-judge panel? Well, this is where the frustrating reality of the judicial system really starts to kick in. Under a legal doctrine known as the rule of orderliness, a 3-judge panel of an appellate court is completely bound by the decisions of prior panels in the same circuit. Because the previous 3-judge panel in the Peterson case manufactured a rule saying that the NFA's registration scheme is presumptively lawful unless you can prove exorbitant fees or lengthy wait times, this new panel's hands were really just tied. The judges openly admitted that because Peterson controls the circuit, they had no choice but to uphold the conviction. But this is where the story takes a wild turn that should also have the ATF absolutely sweating and concerned about the status of the NFA. Circuit Judge Edith Brown Clement was joined by Stuart Kyle Duncan, who issued a fiery concurring opinion aimed directly at destroying the Peterson precedent. They wrote very bluntly that Peterson was a massive mistake that needs to be revisited and overturned by the full en banc panel court in the Fifth Circuit. They pointed out that Peterson took a random, modest footnote out of Bruin and that Supreme Court precedent and twisted it into a binding legal doctrine, which never should have been created or used. And now Mr. Comeau's legal team did not waste any time. They did not waste a single second, and they followed up on that announcement and that ruling. On July 2nd, they officially filed their petition for a rehearing en banc in the Fifth Circuit, demanding that the full bench of the Fifth Circuit assemble to eventually throw out the Peterson ruling. The second that petition hit the docket, the court automatically canceled the mandate that was issued by the 3-judge panel, freezing that case also in place. And the Fifth Circuit is clearly taking this incredibly serious. On July 8th, the court issued a directive explicitly ordering that the Trump DOJ file an opposition to the response. And also in response to that, kind of sensing the danger, the DOJ immediately kind of panicked and filed a motion to extend out their response deadline. They wanted all the way through August 7th. But in response to that, the Fifth Circuit kind of slammed the door right in their face. In an order that was just issued by the Fifth Circuit en banc panel, the court officially denied the government's motion for an extension of time, keeping the pressure directly on the DOJ, forcing them to have to file that response when it was originally set, which is July 20th. The court is refusing to let the government stall this anymore. So what does this mean going forward? Well, this simply means that this NFA challenge has now accelerated and it's going in front of the Fifth Circuit en banc panel. We already had those 2 judges on the Fifth Circuit signal that they would like to revisit this, that they think the Peterson case is incorrect, that the analysis is incorrect and it needs to be overturned. And now we will see if the full en banc panel court in the Fifth Circuit agrees with that type of logic. If the full court goes en banc, they are completely free to rule however they want. They do not have to follow the rule of orderliness, and they can permanently dismantle the Peterson framework going forward. And if they strike that precedent down, the federal government will finally be forced to face a true Bruin 2-step analysis when it comes to the NFA and these type of suppressor restrictions. A full court rehearing and positive decision would no doubt also help Mr. Peterson, who is currently sitting in prison because of that incorrect ruling. So the cracks in the NFA are wider today than they have ever been, and now the Fifth Circuit en banc panel is considering if they want to take a closer look at the NFA's restrictions on suppressors. So let me know your thoughts down below. What do you think is going to happen? How do you think that this is going to play out at the Fifth Circuit level? Will the full en banc panel take a review of this case? And if they do, will they uphold the Peterson framework, simply saying that the NFA operates like a shall issue system, it's a shall issue permit, and therefore is lawful? Or are they going to strike down that type of logic and apply the correct analysis, which is the Bruin 2-step analysis? Let me know your thoughts down below in the comment section. Also, if you like this video and you would like to support the channel, one of the best ways to do that is simply to like, comment, and subscribe. Also, make sure you turn on all notifications, turn on the notification bell, because that helps to ensure that you get these videos when I release them and you constantly get updates on these issues. But as always, thank you guys so much for all of your support. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.